Thank you for clicking and learning. Today, we're talking about when somebody should apply for disability um, when they think they're disabled. There's a few black and white rules. You cannot successfully apply and have your application progress if you are still working full-time or substantially earning from your work activity. So that can include some part-time work too. Doesn't include all part-time work though, so you're going to want to have a good analysis of that. Sometimes we can bring back an onset date many months because the person was working but wasn't working enough to prevent him from filing. And that can be a really beautiful thing for them. But there's a page on the Social Security Administration website that says you should file for disability as soon as you become disabled. Well, that's such a loaded question. And I don't much appreciate that response because as the SSA tells us, the definition of whether you are disabled or not is reserved to the commissioner. So who's to say at that juncture if you are disabled? It's obviously open to interpretation and analysis, and a particular consumer is likely not going to have the knowledge to be able to evaluate that. And even with the best of us attorneys, we cannot say for sure if someone is disabled under the law because it is reserved for the commissioner. So some might interpret that to mean as soon as you stop working. Again, that's a good starting point, but there are sometimes very good reasons, and this is not unusual, to not file the moment you stop working full-time. And let me just go over that really quickly, because when you stop working, and I've seen this in some of the commentary in the back files from the SSA on cases, if you have the same medical evidence you had before you stopped working, even if you're a diligent, patient trying to follow up on the growing impairments, if your evidence, your medical records say the same thing today, now that you filed, that they did 2 weeks ago when you hadn't yet filed and you were still working, when you were still working, that evidence, as weird as it may sound, depicted or can be held to be evidence of what impairments you can work with or at that level of severity. So if you have not had something else go on, such as a lot more complaining about pain, if it's grown, or diagnostics that pinpoint a severity that's different than maybe a year ago when you last had an MRI. So if they don't see a reason why you would stop working when you could work before, that could throw a monkey wrench in it. Particularly at the early and reconsideration level, because that's more of a black and white, go by the book ruling. So that's one thing, there's no difference. And the one way to remedy that is to use the first few months to really take care of yourself and get that more robust treatment and follow up. This is true even if there's no cure for what you have. I see people say, well, I haven't been going to the doctor because they can't help me. They told me that, I'm going to be like this forever. And there's no, I just have to learn to live with it. That's not a good reason if you have an SS case or want to have one to not go, because you just killed your opportunity to win your case, most likely. So filing as soon as you stop working can be an Achilles heel, because you may be selling out your review. It's called initial on your initial application. That's the first review you're going to get, the first medical workup by the SSA. So if you don't have decent goods that show why you can't work now, while you could, 2 months ago or a week ago, you're basically wasting that first review. And that first review could be 6 months, could be longer, and you are potentially wasting it. Then that means you will appeal for a reconsideration, which does happen to most people, but not all. So why throw away that first opportunity? And on reconsideration, because that's often considered, and this is not official, it's just what many people think, it's a rubber stamp of the initial decision, short of some brand new evidence coming down the pike, which is what we always strive to find. So that the reconsideration stage is not a waste, but wasting the first one might give you more of a chance of wasting the second. If you waste the second, meaning you don't prevail, you have to appeal for a hearing before an administrative law judge. All fine and good. That's probably the majority of cases, maybe close to it. Maybe for some people, it's all their cases. Not for us, but it is definitely a significant portion. So wasting the first two is not the best idea, because then the ALJ hearing wait tends to be, historically anyway, although this has kind of been changing more recently, I'd say in the last 4 years when they hired new judges, which was great. But your ALJ hearing is almost the last bite of the apple, short of an administrative appeal to the appeals council, which is a little different and doesn't hold a lot of water. So you do not want to waste your initial and your reconsideration stages by knowingly not having the goods. You want your evidence to be evaluated and be as strong as it can be. It's also going to mean it's going to be stronger for the administrative law judge too. So I do think that you're going to increase your chances of winning overall, not to mention winning sooner. So keep that in mind. Speak to your attorney about, should I be filing right now, or is this just going to be spinning our wheels and wasting my opportunity? And we're going to be at an ALJ hearing in a year anyway. It takes a little talk, it takes a little going over, but I think it's worth it. And sometimes if you wait a few months, you will find that you win on initial and you never have to bother with reconsideration or having a hearing and going under testimony and all that jazz. So give it some thought. If you have any questions, feel free to reach out. You can always reach me through joydisability.com, which has all of my contact information. Thank you for clicking and learning, and we'll see you the next time. Bye-bye now.